All right. We are recording, so we're good to go. All right. Well, good afternoon, everyone, and welcome to today's Cafe Conversation, 5 questions your core team must discuss before serving in-home families. My name is William Moore, and I'm with OJJDP's Office of Juvenile Justice National Training and Technical Assistance Center. And as your technical host, I would like to take a couple of minutes to discuss a few features of Adobe Connect to keep in mind. Please note that this webinar is indeed being recorded and will be published on Intact's YouTube channel once the webinar is complete. To access past webinar events or even archived events, you can do so by going to Intact's YouTube page. You can also receive the transcript and other support materials by contacting OJJDP TTA at usdoj.gov. For those wishing to download any PowerPoint slides or other important handouts, you may do so by downloading the items in the handouts pod. Simply click on the name of the handout and then click the download button. Following or during today's Cafe Conversation, you will be able to submit your questions to our presenters and to our moderator. In order to do so, just simply go to our chat box, type in your question, and then select enter or click the icon to allow for you to send your question in. We will take your questions periodically throughout today's presentation. If you're viewing by yourself, there's no need to type anything at this time. However, if you're viewing in a group, please go to the chat window and type in the total number of additional people in the room with you today. If you're viewing alone, there's no need to type anything at this time. And I'll give you all a couple of minutes to do so. If you could, please go to the chat window and type in the total number of additional people in the room with you today. If you're viewing alone, there's no need to type anything at this time. Following today's webinar, attendees will be sent a certificate of attendance. This certificate is sent approximately 1 hour following the conclusion of today's event, and it's sent via an Adobe Connect thank you email. Please note that only individuals who are signed on into the virtual room will receive a certificate. I will now turn today's webinar over to our moderator, Ashay Shah. For today's Cafe Conversation. Thank you.
Thank you, William. And thank you, everybody, for joining us today for this Cafe Conversation on serving in-home families. So my name is Ashay. I'm a program associate here at CFF, and I'll be hosting today's webinar. It's definitely a timely one, given the increased attention on family separation, the traumatic effects of family separation, and the focus on keeping children in home versus removal. We're seeing this focused attention at the policy level with the Families First legislation, but also at the local level. We're seeing communities much more interested in prevention efforts and moving upstream and preventing maltreatment. So today we have a great diverse and cross-discipline group of panelists to share their experience in this with this issue. So we'll start there. I'll let them introduce themselves. We can move from right to left, and we can start with Mimi. So Mimi, can you tell us a little bit about yourself, including what you do, and then finally, why is this topic important to you?
Thanks, Ashay. Hi, everyone. My name is Mimi Laver. I am the Director of Legal Representation at the ABA Center on Children and the Law. In that role, I help all kinds of jurisdictions improve their legal representation for parents, for children, and for child welfare agencies. And this topic is important to me because I think families do better when they're together. And if communities can strengthen families and leave the kids at home safely, that's certainly ideal. And I think judges and lawyers have a big role to play in ensuring that everybody's liberty interests are intact while families are being strengthened together.
Great. Thank you, Mimi. Magistrate Vihil?
Hi, I'm Magistrate Vihil from El Paso County, Colorado. I run Family Treatment Drug Court, which is a placement prevention program based on dependency and neglect cases, in which substance abuse is one of the primary presenting, though not the only presenting issue. I also run I manage a traditional docket of dependency and neglect cases, which are, when I say traditional, I mean a non-problem solving court approach. So I have both perspectives. One is the traditional dependency and neglect, and then the problem-solving placement prevention model. I have had this docket since October of 2011. I think it's probably the thing I've enjoyed most and found most meaningful in all of my career. And the placement prevention piece has, we have an incredible multidisciplinary team of professionals that works very hard as a group within our community to ensure children can remain with families, specifically with parents, especially while parents complete their treatment plans. And I've just found it to be probably the most important, meaningful work I've been able to do in my career.
Great, thank you. Kim and Angela from Trumbull.
Good afternoon, everyone. My name is Kim Rubel. I'm a supervisor of recovery services with Trumbull County Children's Services, which is a county in northeastern Ohio. It is not a large metropolitan county. Our population is approximately 200,000 people. Why this is important to me is our community has been especially hard hit by the opiate epidemic in the last 10 years. Definitely it's intensified within the last 5 years. Our community has also been hit especially hard by plant closings. We have a high level of unemployment, a lot of families facing, multiple stressors. I currently supervise 3 teams. I have 3 social workers, caseworkers who are paired with 2 different peer recovery coaches who are employees of our agency and have lived experience in both child welfare and addiction. We pair our peer recovery coaches with our caseworkers in engaging families and helping them to get into treatment. And one of my peer recovery coaches is joining me for the webinar today, and it's Angela Cochran sitting next to me.
Hi, everyone. I'm Angela Cochran. So just to tell you a little bit about myself, I am the recovery coach here at Trumbull County Children's Services. I do have a lived experience with addiction and recovery. I currently have been in recovery for 6.5 years. Just to kind of add to that, I've also had child welfare experience. My kids have been in foster homes before, and I've successfully reunified with my children. This means a lot to me because of the personal experience that I share serving the families that we serve. It's really meaningful to me because it's something I'm passionate about. I want to give hope and inspiration to others and give guidance, in the recovery, also within the child welfare. So this is something that, that's really meaningful to me and I'm passionate about because I want to be able to share my story and help others achieve the same successes that I've achieved myself.
Great. Thank you so much. Before we jump into some of the more substantive questions, I know, Magistrate, your program is unique, and I think people can really learn from kind of the structure and process of your program. Would you mind saying just a little bit more about the program itself and kind of who is eligible?
Sure. So so Family Treatment Drug Court is it's been in existence since 2002 in our jurisdiction. It is the largest and oldest family drug court program in our state. It is one of the few placement prevention programs that exist, and it's been that way since it began. When I say placement prevention, one of the eligibility criteria for our program is that but for this program, children would be placed out of the care of their families, and so especially in foster care, primarily foster care. And so that's actually one of our criteria that we look at. Substance abuse is a primary presenting concern, though certainly not the only issue. We are a substance abuse treatment court, but certainly with that comes all of the other safety and risk concerns that we need to take into consideration, such as family violence, domestic violence, mental health, and so forth. And so we're a full treatment court and a traditional dependency and neglect approach. We use intensive wraparound services, in-home services, and extensive court involvement or court monitoring and engagement with families and extended family members. We work very heavily with kin and kin-like resources within the community to prevent placement out of the care of parents while they are working their treatment plans and working towards recovery. And so what we found in our jurisdiction is that keeping kids or maintaining children home with parents has become a stronger motivator than working towards reunification. And we require a lot of our participants, but the benefit is huge as they have their children with them all the time. And it would not be possible without the incredible collaboration we have within our community. We have a very multidisciplinary team that has put together this safety net for our families. We're a very large community. We are a large jurisdiction. And so we're not able to serve every family that comes into our courts with that would otherwise maybe meet the criteria, but we serve highest risk, highest need, and hope to try and get as many people into the program as possible. But we are capped at 56 families, which can ultimately be about 80 to 100 adults at any given time.
Okay, great, thank you. So you mentioned safety a couple times, and that we know that this is a really big issue, especially when talking about serving in-home families and keeping kids in the home. This was the most asked question from our registrants for this webinar. So just starting there, we can start with Trumbull. Can you tell us a little bit about the safety decision-making approach in your jurisdiction? What strategies are you using to ensure safety?
Yes, I'd be glad to talk more about that. In our jurisdiction, well over 50% of all referrals that we receive at the intake level have some component of substance use as a primary concern. We have an assessment unit who goes out and makes initial contacts with the family and uses an instrument, a safety assessment instrument that we call CAPMAS, which stands for the Comprehensive Assessment and Planning Module. That safety assessment looks at 15 different safety factors that can affect the safety of children. Substance use is just one of those factors. We're also assessing if there's a mental health concern, whether there's violence in the home, whether the children's basic needs are being met, in determining if the children are safe in the home. If we do identify that there's a safety concern, our first action is to try to join with that family and partner with that family in coming up with a solution to ensure that the children are safe, but not necessarily have to be placed into foster care or removed from the home. In a substance use case, we typically are going to try to reach consensus and agreement with the family on, is there a sober adult that we can partner with who can either reside in that home with the parent while they're taking steps towards getting to treatment and getting into recovery. And if that's not possible, is there a family member or even a close friend that the children could reside with while those steps are being taken. I would say in the vast majority of our initial assessment and intake cases, we're successful in forming that partnership with families, being able to develop safety plans with them, which are completely voluntary for a client to do. It does not involve our court system at all, and families agree to work with us on that level. Once we've established that, if substance use is the primary concern, it will then get referred to my unit. Again, I have 3 teams of people who provide services in dyads of caseworkers and family care mentors. That team will then go out and meet with the family, explain the programs that we have and the services that we provide. At this point in time, and both of these programs are being done through grants. We've designed it so that we want families to voluntarily enter into this program. We're not court-ordering people to participate in these programs because they are very intensive services. Caseworkers and peer recovery coaches will be meeting with the families weekly, sometimes more than weekly, and working very closely in getting them into treatment and working with their treatment providers and doing family team meetings with extended family. Angela, could you elaborate a little bit on what an initial meeting with a family in terms of how you engage them and let them know about the services that we can offer them?
Well, me and a caseworker go out to the home, typically with the assessment worker. That way the family is already comfortable and familiar with one of our agency staff. We typically introduce ourselves, and start with what the program is. Currently, I'm working with a program called the QUIC program. It's just an intensive case management where we do see the families weekly together with the caseworker or separately if they feel more comfortable meeting with me separate from the caseworker. And then what we do is, we just kind of have a conversation. We try to implement the UNCOPE, which is a substance use screening tool on the family with open-ended questions, like motivational interviewing. That way it kind of leads to more of a conversation with the families about their substance use. And we try to build off of that trust. I think the bigger piece of that is having me in the room, and I get to, share with the families that I'm working with that I do have substance use disorder myself and that I am in recovery. And that kind of opens a lot of doors with the families once they realize that there's somebody sitting in the room that's got that lived experience. It kind of breaks down some barriers and walls with the families that we're working with, and there's some trust there. And like I said, sometimes that trust will be just one-on-one with me and the family members or with the caseworker in the room. Typically what we've been seeing a lot of is a lot of the honesty being shown with the caseworker present. So it's just that engagement piece is really huge because a lot of the times when the assessment workers are going out, we don't get that honesty piece and we don't get that openness with the families to talk about what the issues really are.
Great. Great. Thank you. Can you say a little bit about the importance of timely access to services? I know you guys are really good about getting people into services quickly. Can you say anything about that and how that works with families?
Absolutely. So once we identify a family member with a substance use disorder, what we like to do is ask if they already are involved in treatment. Then we go off of that, have them sign a release as necessary so that we can work very closely with the treatment provider. So if they're not involved in any kind of treatment, part of my role is getting them connected to treatment. And sometimes that barrier can look like there's no, health insurance or an ID in order to get into any kind of treatment, because nowadays they want a valid ID in order for them to be accepted into any kind of treatment. That's something that I can, help them with, whether it's getting them an ID or taking them down to Jobs and Family Services, getting them their medical so that we can get them engaged in treatment as soon as possible. We typically like to see a family engaged in treatment within the first 30 days of an open case. And we've seen a lot of success with that. Once treatment is involved, they're taking more necessary steps in the right direction, but that doesn't always mean, that they're not going to relapse. When that happens, that's where we kind of step in and we're that, that extra accountability, but also that supportive role as well. That weekly check-in just to see where they're at, what they're doing. We have conversations and updates with their counselors from treatment providers just to ensure that they're being treatment compliant, that they're rendering clean screens, and that they're doing what's necessary. And kind of add to that as well, I also have the capabilities of taking them to any kind of 12-step meeting. And sometimes that's during work hours, sometimes it's later in the evening. I try to work around their schedules, but getting them connected to some kind of recovery community after treatment, something that's going to be more long-term for them.
Got it. Thank you. So we're getting a lot of questions already, and I'll do my best to moderate. One of these that I'm seeing, and I also had a similar question about the voluntary nature of some of these services. The question here is, what happens if a family decides, what happens if a family decides they do not want to comply with the voluntary safety plan after it's been in place? So just a little bit about how those different tracks in child welfare work. Maybe more.
Yes, that's a very relevant question, and that very much does happen in our jurisdiction. But it is not the majority of cases. The majority of cases that we are able to develop safety plans with, we're able to continue working with the family on a voluntary basis and not involve the courts. In the minority of cases where families either cannot or will not follow the safety plan that we have developed, we will staff with our legal department to determine if we have enough grounds to file a dependency action in court, and that would be our next step. Now, whether that means that in some of those situations it may be that the children are with a relative or could stay with a relative, and our action would be to file an action for that relative to be the temporary custodian, with us having what's called a protection supervision order, and our goal is still to try to engage and work with that family in getting them into treatment and services, but having the court involved in that process. With both our legal cases and as well as our voluntary cases, we also have a family dependency treatment court program. It does require that they have a legal case through child welfare. We do have a lot of difficulty with our voluntary population getting them to want to do that because they don't want to have the courts involved in their life. The cases that we successfully get to opt in to do family dependency treatment court tend to be cases where children are either placed with family through a temporary custody order or are in foster care, and it seems to be an easier sell to get those families to opt in.
Yeah.
Does that adequately answer your question?
Absolutely, and I think this relates to engaging families, which we'll get into just in a bit. But I did want to jump to the magistrate, ask a similar question about making safety decisions within your court, and then, if you can, address one of these other questions that has come in about It looks like about pre-petition. So do you have a non-detained petition filed in those cases?
Sure. So the way that cases come to me, before the case is ever filed with the court, they are already being screened for family treatment drug court. Many of our cases involve families where they have a child that has been born drug exposed. All of the cases are going to be coming to the court. So they're not, it may be where there have been voluntary services offered, but they were not able to engage the family, or it was not ultimately successful. And so they are going to have court involvement on some level. They are screened for family treatment drug court before any petition is filed. If the family is interested in the intensity of the services that we offer as a placement prevention approach, then services begin before it's ever filed with the court, meaning they start UAs, they do UAs 3 times a week. They're going to be linked with one of our, the drug court team. It's called Savio Direct Link. It's the program we use. So they will be linked with a child protection therapist that will start working with their family, and we'll be doing some expedited assessments. When that agreement starts to form, I get a call, or the duty judge, whoever's on call at the court, will receive the call. They will be informed that the case has been screened and accepted for family treatment drug court. Families interested in that program and is eligible. So the case will be filed. A petition is filed, but it is with custody remaining with a parent, and the department and the county are exercising what we would call protective supervision at that point in time. The case is filed, but children are in the legal custody of their parents. For safety and risk, we always require that there's a sober caregiver at all times for all of our children. That we may be family, it may be a co-parent, it may be a friend, it may be, sometimes we've had neighbors, believe it or not, we've had landlords, we are willing to be creative to create some of that community for the individual. So whoever they have a relationship with that they've recommended, that we start screening for a safety net for them, a sober caregiver. So typically, for example, we may have a family member move in to the home with the parent or parents, and be their assist with as their sober caregiver, so that we're mitigating some of that safety and risk with always ensuring that there's a sober caregiver for the child or children. Our program allows children, any case that has at least one child under the age of 10, and so, but we can certainly have all ages. And one of the things I should also say is that at this point in time, we're also screening for needs for the children as well. Those cases that have older children sometimes have children that also come in with substance abuse needs, and that's something that we're trying to serve the whole family, not just one parent. And so we're assessing all of those safety and risk concerns, and as part of our safety net, we have the child protection therapist that starts working with the family immediately, and that's before court orders come in place. Once it comes to the court, it is ordered that they continue to work with those professionals. They also will start treatment services, such as doing an evaluation for substance abuse treatment. There may be other evaluations that they complete as well, such as mental health or domestic violence, things like that. But they will have essentially 10 to 20 hours of in-home services beginning immediately, and they are coming to the court at least one time a week to meet with me and our drug court team. They also will have a team with all of their therapeutic providers separately at the office of their child protection therapist. And so in addition to the in-home services, the sober caregiver, they have immediate and extensive time at court We have a drug court coordinator that will begin to engage families through an orientation to the program, so that to decrease just, I guess, the amount of stress and anxiety that comes with the whole court experience, and so that everyone knows really what to expect and who everyone is and how to reach out when you need help and you have questions. We also in our jurisdiction have started an expedited appointment of respondent parent counsel as well as guardians ad litem, and that's another piece of our safety plan. Not only are they meeting with their caseworker and their child protection therapist, but before the case comes to the court, they also will be having a guardian ad litem will be appointed to represent the best interests of the children, and an attorney will be appointed to represent parents. It is a traditional dependency and neglect case with all of those rights and intact. They have not waived any of their rights, so they immediately get counsel. But in our program, they actually will get their counsel before the case is ever filed, so that they can start going over their options and figuring out what's really in the best interest for themselves and their family. I also have found that helps, I think, parents just be less stressed and intimidated and afraid and anxious about the process. I think anytime you're dealing with the courts and there's this concern of possible removal of your children from your care, there's a great deal of fear involved and anxiety, understandably. And so having counsel appointed right away helps everyone work better together. So we have that beginning as an expedited, on an expedited basis as well.
Thank you.
Hopefully
Mimi,
that answers some of your questions.
Definitely, yes. We'll come back to a couple, but jump into Mimi. I'm sure you're glad to hear that there is early appointment of counsel. Just wondering what your thoughts are about an attorney's role in kind of the safety decision-making process.
Sure, thanks, Asha. And yep, I was really happy to hear Magistrate Vigil talking about the role of counsel and the role that she plays in the court. I think there are a number of different ways that lawyers get involved or should be getting involved in the safety decision-making that goes on, as well as just in providing or in ensuring that reasonable efforts to prevent removal are happening. As the magistrate was mentioning, there's a trust issue that happens when parents have representation. When children have representation, they now know that there is somebody on their team who can help advise them and ensure that entering, an intensive program really is going to be helpful, that they can believe that that the goals that the program has match up with the goals that they have for their family without feeling maybe extra pressure. I think Trumbull and El Paso are doing an amazing job of trying to ensure that the right families are in the program, that they're being very careful about who gets screened in and who isn't getting screened in. But it's really important when doing prevention work that we look at what is the actual safety issue, and can the services, the reasonable efforts that are being provided to the family resolve the safety issues, not just any issue, but the safety issues that are related to the children. Otherwise, we have a concern of widening the net, that too many eyes from the system on a family can sometimes lead to children being removed when they shouldn't be, when there's not a safety issue. And so I appreciate what Kim and Angela were talking about in terms of the community aspect, the community services that are being put into place, what the magistrate was talking about in terms of the intensive issue services, as well as the lawyer looking out. But I think, that my takeaway in terms of safety up front is that we really want to make sure that if there is a safety issue, that the services we put into place impact that issue. Parents can use substances and have it not impact their parenting. And so a really important question that needs to be happening is, are these, is the substance use impacting the safe parenting in this family? And if not, then pressure shouldn't be put on families to feel that they must comply with services, must be involved in a court. If the parenting is impacted, then of course we want these services to be put into place, and we want parents' rights to be protected as they move forward through the system.
Mm-hmm. Thank you. I'm hearing trust as kind of a common theme, and I want to ask a question to all of you. I know you have these programs and added supports in place now to support intact families, but was there ever, can you say anything about any barriers related to other systems or partners in other systems not necessarily trusting, having issues with trust in keeping families intact, not necessarily being fully aware of the extra added support that you all provide in these more innovative programs?
I can answer. I have something to say on that point, if it's all right.
Sure.
And this is Magistrate Behill. So yes, I would say I think that that's a very important issue. A couple of things that were just raised. Absolutely, I would agree with. First of all, I think there is a trust issue. What I handle both the problem-solving court docket, and I also handle a traditional dependency and neglect docket. And what I would say is they're very different approaches to the issue of to really the same types of cases. They're very different approaches, and the professionals that, and I'm certainly not criticizing anyone's intention. I think that they are all there, whether it's the Department of Human Services or Guardians ad litem or Respondent Parent Council. Everyone is there for good reasons, and I'm certainly not criticizing. But I do think that there is a tendency in a traditional docket in our jurisdiction, certainly, to not really understand the safety and risk concerns, to maybe try to treat issues that we don't really need to treat in a dependency neglect case that are really beyond safety and risk. I think that there are trust issues between counsel and between the social workers that not everyone believes that we're all working for the same goal. And in the problem-solving court in my program anyway, we, as all traditional problem-solving court models, we train together. We attend national conferences together on safety and risk, on what is a child welfare concern, on substance abuse and understanding substance abuse and recovery. And so we're all working towards the same understanding. We all have our very different roles to play in the courtroom in a problem-solving court, and we all understand each other's roles. But at the end of the day, in the problem-solving court, we have the same goal, and that's why we're part of that problem-solving court. And keeping children with their families is part of that common goal, is maintaining that safety net and not maybe overreaching or treating things we don't need to treat in this particular case. That's part of that common goal. And so, unfortunately, in our non-problem-solving court adversarial approach, I would say, we don't always have that same shared understanding of what the goal is, and that's where things like reasonable efforts come up, or maybe treatment plans that are overbroad, or those kinds of concerns really do appear.
Thank you.
Ashley, if I could add a little bit, I think historically, child welfare agencies were mistrusted by families, by members of, especially families living in poverty, maybe families of color, and not only child welfare agencies, but many government agencies aren't well trusted in certain communities, in many communities. And when child welfare comes to say that they want to help, but then there's pressure on families, both parents and children, to comply with services or else. That doesn't always feel voluntary, and people are scared. It's a terrible, it's a very traumatic event to have your children removed. And when you hear from your family and your neighbors and everybody around you that when child welfare gets involved, they're there to take their children, it's hard to be trusting. And so I think problem-solving courts go a very long way to building trust and good faith. And also the system of representation that especially Colorado is building now goes a long way. So the attorneys in Colorado are part of a legal team that also involves social workers. And those social workers, we call it a multidisciplinary model of representation, those social workers also help to build trust for the family and help them understand that what the services are that are being implemented are really part of a case plan that's directly related to the safety issues in their family, and not just any old issue like a random parenting or a GED or some of the services that in the past maybe people were compelled to comply with even if it didn't relate to safety. And so I think by having a legal team and being part of a court like both of the sites are describing, where the goal really is to strengthen the family and keep the child at home, I think that goes a long way to helping families believe that some of the issues they are experiencing can be overcome while they get to keep their family intact.
Great. That's a great lead to our kind of next set of questions, which is about engagement, and in particular the special issues with engagement when we're dealing with voluntary cases and substance disorders. So I'll start with Trumbull. Can you say a little bit about the engagement process? What are the potential challenges of engaging families in voluntary services?
Yes, I believe that Magistrate Vigil, outlined a lot of those issues, but certainly developing trust with the family is the biggest challenge that we face. Many of our families are very afraid to interact with the child welfare system, and our first interactions with them, they're on guard, they're afraid, they're worried that our only goal is to remove their children, and we spend a lot of time, engaging with them and letting them know that we want them to be successful and we want them to stay together as a family as long as we can ensure that the children are safe. And getting them to be more open about how substance use is impacting their ability to be a parent. Many of our parents are initially in a lot of denial about how their substance use has any or no impact on their parenting, and doing some identification and some education. And that one of the first things that my team uses is an assessment tool called the ONCOPE, which is a brief interviewing technique with 6 questions to help them understand how their substance use is affecting them and whether it's a problem for them or not. We have a lot of our families, identify and score to an extent that they need additional assessment. We ask those questions in an open-ended way. For example, one of the questions is, tell me about a time that you tried to cut back on your use and you weren't able to. Rather than asking that as a yes/no question, we're asking it in a more conversational way. Obviously, having the peer recovery coach present and sharing her lived experience definitely helps people to realize that, hey, I'm not alone, and someone else has been through that. Helps them engage more. Angela, would you like to elaborate a little bit more on that building trust and overcoming fears with families.
I mean, from my perspective, I've been where they're at as a family, having children's services come into the home, and have that conversation and having to own up and be honest about the substance use. That's probably one of the biggest things that we run into going out to the homes and talking with the parents, is their honesty about their substance use. We get a lot of minimizing, and rationalizing because of the use, or they'll say, I'm using this, but their drug screens are showing positive for something else. So just having that piece of me being able to talk to them, and having, that trust-building conversation by me sharing some of my lived experience, and letting them know that, by being honest about my own substance use, it opened the doors in order to better my own future and be successful with recovery as well as reunification with my children. So that's probably one of the biggest barriers that I face and challenges of getting families engaged, because they know when children's services are coming to their door, a lot of them, once they answer, they're involved with us, whether they like it or not. It's, their involvement with us. We want that involvement to be more meaningful, and we want the parents to be, engaging and actually do what's expected of them. And sometimes that's hard to do because it's, it's changing their lifestyles, making different choices. So that's probably my biggest challenge, though, is the honesty piece.
Great. Thank you. Magistrate, do you have anything to say about engaging families, maybe some specific strategy? I mean, I know you've mentioned a couple, but some specific strategies from on the bench that you use to engage families?
I might want to not respond to that.
Sure. I think that, I see the families that come into the court at most every 7 days, sometimes more than that. And so part of it is building a relationship. I do believe that the fact that we start from the very beginning talking about how can we prevent placement, and it goes a long way. I am from the very beginning discussing with every individual what do they believe their primary need is to how can we help them be successful. And so there's a huge amount of communication, much more so than I would say in a traditional docket. I feel that I get to know families much better in family treatment drug court, and the interaction is just very different. I will say also, though, that it's not just me that's engaging families differently. The respondent parent council and guardians ad litem and our child protection therapist and our department, we have assigned caseworkers with the department that are just for this role with our program. They also are engaging with families very differently because we are looking at it from the placement prevention framework. And so they've already started establishing a relationship before the case even comes to court. And so they know about the program, they know about me, they know what will happen before they come in the courtroom. And then when they do come, and it does happen that way, and things are as they expect, or within that realm of possible expectation, I think it reaffirms that they can trust what I'm telling them. They learn that I'm going to do what I say, and that my intention is to work with them and this team of professionals that are really experts to try and find ways to keep their children with them and their family. And so it's really a completely different level of interaction, of conversation, and frequency of conversation. I'm meeting with them all the time as part of this team. But I will say it is a process, and I know that, and I don't expect them to come in the door and be open and honest and and happy to be there and ready to get started with treatment. It's a process, and I fully understand that, and I want to meet them where they're at. And so my expectations are realistic, and when they react with distrust, they being the family members, whether it's a parent or their parents or their relatives, because we deal with extended families, not just one individual. In a dependency neglect case, we have the whole family is there often, or at least that's what we try and have. I want to get their support system there, or who will become their support system there at the table. And we can start working together. And so I'm fine with that. I'm fine with them being distrustful of me and of the process and of the system. I get it. I understand. I know where it's coming from. And so I think that I recognize that. I validate that in the sense that I let them know it's okay, I understand, and let's work through this together.
You mentioned the importance of buy-in from your partners who play a really big role in engaging families. I'm sure it's not always been like that. Can you say a little bit about the process of, getting buy-in from specifically attorneys on the model?
I think that I think that's a great question. The individuals that are part of our drug court team most of them have been part of the drug court team for over a decade, and they're there because they've seen the results. They know that the results are better than on a traditional dependency and neglect case, but there are definitely attorneys within the community who are not part of the program, who are very, they feel that it's maybe too collaborative or selling out their clients or whatever they want to, however they want to phrase it, that are distrustful. And I think that I understand where that perspective is coming from, and so I certainly don't take any offense to it. My point of view is that really I want to figure out what each individual family needs individually. It's got to be individualized, and problem solve through it, and so that they can successfully leave the system and not return. And have a support system out within the community, a natural support system, so that when struggles come up in the future, it doesn't blow up into something that results in court involvement. The community support is absolutely essential, and so even to this day, we have individuals who are not part of the program because they are not comfortable with it. They're not comfortable with maybe a multidisciplinary collaborative process, and that's okay. There certainly is that track, the more adversarial approach, and it is available for anyone who wishes to pursue that route through the courts. So I understand. I think as a system, though, we are really trying to take some of these drug court principles and move them out of drug court and into the just general traditional docket, so that we are offering some of those same services on a smaller scale to families. For example, one thing that we've taken from our drug courts that we're offering, and it's voluntary in our courts, is that everyone could access evaluations on an expedited basis. If you're ready to if you want an expedited return home, if you did not accept drug court and your children may have been removed, we do have a path for more of an expedited process available, and it's voluntary. And so that gives professionals within the community to make their own decisions and hopefully work with their families to figure out what works best for the individual.
That's great. Thank you. There's a couple of questions. I'm doing my best to monitor these. I'm not sure exactly who this is for, but are all treatment services office-based, or do you provide substance use or mental health treatment services within the home? either?
In my program, we do. In my
Go ahead.
in my program, we do. I was going to say in my jurisdiction, in my program anyway, in the drug court program, and it's sometimes, depending on if we can get creative in the non-drug court program, they can be offered in the home as well as in an office setting. So we have all of the above is what I would say. We do both in drug court.
Thank you.
For Trumbull, obviously our peer recovery coach services can be provided in the home. Obviously, casework services are provided in the home. You know, we're trying to provide services to the entire family, not just to a single parent. And we have many services in our county that provide home-based services for children. If we identify that there's a parenting education need or a behavioral, emotional issue with a child, those services can be provided home-based. We also do drug screening home-based, but at this point in time, we do not have a substance use disorder provider that will provide services within the home.
Great. Thank you. We'll come back to some of these questions as well, but I do want to jump to Mimi on the issue of engagement. And you did mention widening the net. And I just want to ask you to expand on that a little and potentially talk about some of the possible unintended consequences of engaging families earlier.
Sure. Thanks, Ashay. What I meant by widening the net is that there are many parents who are using substances who are safe parents, whose children are staying at home, and they may not need these services, and as I was discussing earlier, there's also a lot of families who are very nervous about having systems engaged with their families. When we talk about a service being voluntary, but if the parent doesn't comply, then a petition gets filed. I think that's fine if there's really a safety threat. And therefore a need for a petition, but I worry that with prevention work that there is a possibility that with more eyes on a family, people interpret actions by a parent differently, and we want things to be really objective, not subjective, not we're watching a family because of substance use, but then we see that maybe there's a dirty house issue or some other area that doesn't have to do with safety. We don't want reports being called in for, again, issues not related to safety. And so that's what I mean. I think that that Family First is an amazing, amazing piece of legislation. There's lots of money for prevention, a focus on prevention with substance use and mental health. And in-home parenting services. There's also part of Family First focused on residential treatment where children can be in residence with their parents, and I'm hopeful that states are developing evidence-based programs related to inpatient services where children are with their parents. But when lawyers and judges are not involved in some of the prevention, there is a risk that we could run well-intentioned but run over people's rights. And so I just want all of us to be very careful as we expand prevention services that we are expanding it in a way that really is about strengthening families. I also wanted to mention, so that the fact that Angela is involved in Trumbull County is incredible. And so the peer recovery program is, I know, has expanded into many, many places. And a similar program has also expanded in the legal community. So there are a number of offices that provide multidisciplinary representation, as I mentioned before, with lawyers, with social workers, but also with people with lived experience. They're sometimes called parent partners, parent allies, parent mentors. And when people with lived experience are part of the legal team, that is another way of providing engagement in all of the ways that Angela was describing. But there are a number of states that have been working to expand the use of parent partners in the legal frame, and I think that's important to think about and also to expand. And one other area of legal engagement that has been wonderful in the couple of places where it's happening is that lawyers have been engaged to do sort of the issues related to things like housing, domestic violence, education. And so when lawyers can get engaged before removal, sometimes they can help take care of some of the legal issues that that lead to children coming into care. Again, if there's a substance use issue, all of the programs that Trumbull and El Paso have been talking about are incredibly relevant, but also just for our participants to think about ways to engage lawyers in some of the other related issues that can help families keep children safely at home.
Great. Thank you, Mimi. So we usually do this where we do the last half an hour doing responding to some of these questions, and I'm looking through to any of our panelists, if you see anything that you want to respond to, please let me know. I'm seeing one here about screening and eligibility for your program. So from Joyce Shelton, what key factors are you screening for when determining eligibility for FTCS program? Either
I'm sorry, what was? Could you repeat the question?
Sure. Yeah. It's what are the key factors? So what key factors are you screening for when determining eligibility for your Family Drug Court program?
Okay. And my video is frozen because it was moving all over the place. So this is Magistrate V. Hill speaking. The key factors for screening for eligibility. So it's a case that's one of the primary presenting issues that's bringing the case to the court. It is a case that's is heading towards the filing of a dependency and neglect case. So it has not been filed yet, but that's the direction that it's heading. Maybe voluntary services are being offered, and maybe there's not as much engagement is needed, or there's a serious safety and risk concern that arises, maybe an incident where there was a parental arrest, for example, that kind of thing, which I would just let you know that the fact that parents have been arrested does not mean they're not eligible for our program. They absolutely would still be eligible as long as the incarceration period is not going to prevent them from engaging in services within a reasonable amount of time. If they're going to be incarcerated for years, then that likely would not mean eligibility. But that's not generally the case. And so there was an incident, and voluntary services are not really where they're headed right now. Family Treatment Drug Court is voluntary, I should say, though, and that means that they don't have to jump into what really is a lot of engagement with a lot of professionals. They're going to have social workers. They're going to have therapists, a lot of therapists meeting with them. They will have an early appointment of counsel, so they will then have attorneys, a guardian ad litem. Every parent has their own individual attorney, and all of that happens as soon as they say, yes, I accept Family Treatment Drug Court. They're not locked in, though, I should say. They haven't been formally locked in. It's not an order of the court. This is all pre-filing. And the eligibility criteria, as I indicated, does require that there's a child in the home, at least one that's under the age of 10. Placement out of the care of a parent is likely, but for these intensive in-home services that will be wraparound services that would be provided. And substance abuse is one of the primary presenting issues. We do have a requirement that there's a sober caregiver. We work very creatively with individuals to identify a sober caregiver. And I do want to just say that one thing we will do is train individuals to become a sober caregiver. So even if someone maybe doesn't feel comfortable initially in that role, we have support services that, in terms of our Savio child protection therapist in our department, that they will actually assist with providing some training and education so that those kin-like resources can feel comfortable getting involved to support their friend or relative in this process. And that's a voluntary thing as well. So there's a lot of things that are being offered. I would say once the case comes to the court, I think it's important from an eligibility standpoint to just note that once they've come to the court, they cannot be rescreened. If they've turned it down and it's come to the court and it's maybe post-adjudication, they cannot change their mind about that. And it's unfortunate. I wish we could do that because I think sometimes individuals, in fact, I know sometimes individuals wish they had accepted once they're in the court system. But the reality is that in my jurisdiction, we have so many families that really want placement prevention. They don't want to, they want the help. They want the right help, and they want this support network that's there that we have very limited availability, and we're full 100% of the time. So as soon as a person either graduates the program and case is closed, we have an opening for about a day. And unfortunately, that's the reality of our program. So for eligibility, it has to be done right at the very beginning of the case.
Great. Thank you. Just one quick question. I think you answered this, but do you have a treatment court for cases where children have been removed from the home as well?
Well, we don't have a treatment program for that specifically, but in my program, I was really uncomfortable with the fact that I felt like we were disproportionately harming individuals who really had no one. They could not come up with a single person that could be their sober caregiver. And so what we have in our what I created was, and I had to work with our community team, the professionals that are in our program, the Respondent Parent Council, Guardians Ad Litem, and the Department of Human Services and El Paso County Attorney's Office to create this because of funding issues. I created what we have as an expedited return home so that individuals who have no one, they have not a single person in their life at that moment in time locally that would be available and supportive of them to be a sober caregiver to assist. Their children may get placed out of their care, but if they can still sign into drug court, into my program, and have an expedited return home because of those services, so that we can, once those services are all in place, once the treatment is there and the sobriety monitoring and the in-home services provider has started working with that individual, and they're coming to court every, at least once a week, we can have that expedited return home much faster. So we're talking a matter of like less than 4 to 6 weeks, not months, where you might have months on a traditional dependency neglect case. So we do have that track. It is limited. That is, we are a placement prevention program, but we do offer the expedited return home track. We try and keep it to 5 cases and not more than that, only because we are a self-sustaining. We do not seek outside grant funding to support the program and the extensive services. So we divert what would be funding to pay for foster care placement. We divert those funds to pay for the in-home services. So, and that was an agreement that we as a community made with our Department of Human Services. They really stepped up to the plate on that one, and I certainly want to give them full credit for that. Because it has allowed us to be completely self-sufficient in terms of funding.
That's great. That's great. And that's a great lead to the more general question for all of our panelists about funding and what funding looks like when we're talking about prevention. So we're talking about, I'll ask Mimi specifically about quality and early representation, and then we can ask Trumbull about funding in-home services and some of these more preventative services. So we start with Mimi.
Right. I don't think there's any one great answer. There are different funding sources in different states. For example, early representation for parents in Iowa at Iowa's Legal Aid was funded originally through a grant from the Court Improvement Program, and then they've gone out and found other grants. Prevention lawyering, pre-removal lawyering in New Jersey is paid for basically through the legal services contract that they have with the state. And different states are just trying to use money that they can find. Now that said, as many of you know, in the end of 2018, the Children's Bureau changed their policy to now allow federal dollars, federal 4E dollars, to flow to states for representation of children and parents. And so some states are talking about using these 4E dollars to pay for pre-removal representation. Other states are talking about using the money to advance the multidisciplinary model of representation. There are several different ways that states are going to be using these dollars, but if your jurisdiction is a jurisdiction that would like to examine ways to use representation for parents and for children pre-removal, these 4E dollars may be something that you'd like to consider. On the Family Justice Initiative website, we have a Q&A about 4E funding for parent and child representation, and of course I'd be happy to talk to anybody offline about that opportunity.
Great, thank you. Kim or Angela, about funding?
Yes, this is Kim from Trumbull County. In the state of Ohio, in our county, we currently are relying on 2 grants that we received. One is called Ohio Start, and another is we call it QUIC, which stands for the Quality Improvement for Collaborative Court Teams. The funding that we received from those grants enabled us to hire 2 peer recovery coaches and get them the training that they need. We are planning for sustainability to be able to retain our family peer recovery coaches. We, through our agency, we are licensed through Ohio Mental Health Services and have a clinical director that once these grants end, our plan is to be able to bill Medicaid for peer recovery coach services to be able to continue that programming.
Okay, great. Does anybody else have anything to say about funding? Magistrate, you mentioned some negotiation to redirect funding from Title 4E to in-home services. Can you just say a little bit more about what that process was like and what it looks like now?
So it's so in terms of the redirecting funds that would otherwise go to placement, to pay for placement essentially, is the way it's phrased. Since we're avoiding placement, that money is redirected or reallocated by the Department of Human Services through which they create contracts with an independent provider to provide in-home services. And that was an independent decision that they believed in the placement prevention model, and so fortunately they made the decision to reallocate those funds. I would say, just to follow up on something that Mimi had mentioned, our Office of Respondent Parent Counsel and the Office of Guardian Ad Litem and Office of Child Representative here in Colorado has also provided funding to pay for expedited appointment of guardians ad litem and respondent parent counsel, at least in terms of our drug court cases. It's kind of early stages, early appointment of counsel in Colorado, and we're using Family Treatment Drug Court as a pilot project, testing ground for that. But those offices also are have been willing to allocate some of their funding in their budgets to pay for some of these expedited services, specifically appointment of counsel in their case. As far as now, it's pretty cemented. We don't have to renegotiate that. I think that, which is nice. I think that the program, the model is very successful. The outcomes are tremendously better than our traditional dependency and neglect approach, and that in and of itself has justified the funding. So fortunately, we have a tremendous amount of support. It's been a long process of meeting and collaborating through our best practices committees here in El Paso County, but everyone is very, very supportive of the program now, and and so we don't have to actually renegotiate. It's automatic.
Great. There's one question that just came up. Someone is asking about, did someone say there had to be one child under the age of 10? So just again about the criteria for the program, Magistrate or Kim or Angela.
So that's one of the eligibility criteria for the Family Treatment Drug Court program. This is Magistrate v. Hill in El Paso County. We may have children that are of all ages on any of the cases, but we do have at least one young child on all of the cases. It may be that all of their siblings are in high school, but there's always going to be at least one child, and that's just one of our eligibility criteria. As it turns out that and I think that was part of the department's wish. They really want to make sure that we are focusing, since we have limited funding and limited in-home services, that we're really targeting all of that energy, and from their perspective, I think, towards preserving the youngest children in family homes. So I'm thinking under the age of 5 when I say youngest children. However, we do have children of all ages in the program. I don't want there to be a limitation on age, because I think that we need to serve all of the families.
Got it. Thank you. Sorry to jump around. Go ahead, Kim.
Sorry, Kim from Trumbull County. Our Family Dependency Treatment Court does not have any kind of age criteria. We have families with children of all ages. However, the two different grants that we're working with, we do have different ages that we're targeting. One, we're specifically working with families who are either mothers who are either pregnant and have children in the home, or have an infant under the age of 12 that meets the Ohio definition for CARA. With our other grant program, Ohio Start, it's children who meet that definition that aren't under the age of 1. But our treatment court is open to families with children of all ages.
Great, thank you so much. So we have just about 10 minutes left, and we want to give all of our panelists an opportunity for a closing remark. So I'll give them that question, then we'll go back and do a couple logistics, and then we'll have them answer that question. So the question for our panelists is, in one sentence, what advice would you give to any community that is considering focusing on in-home families? So I'll give you 1 minute to think about that, and I just want to let our audience know about a couple of things. So you can download the Take Action Guide, which is just follow this to our blog spot. Let me go back. There's also a pre-recorded video. And so this covers a lot of the content that we've covered today, kind of in a more condensed fashion, a more produced and condensed fashion. So please go ahead and check that out. And then some contact information. So I think that's it. So I'll pass it over to our panelists, and we can start with whoever wants to start. Again, we can go from right to left, and we can start with Mimi.
thought you said anyone that wanted to go first. I think my advice is really to follow the lead from Trumbull and El Paso counties in a couple of really important ways. Both of those jurisdictions have done an amazing job of engaging stakeholders and community service providers and people with lived experience right from the beginning in growing their programs. And as you probably guessed, I'm really also very excited about El Paso working so closely with their lawyers right from the beginning of a case. I think that's essential, and I think it goes a long way to furthering everybody's goal of strengthening families while children remain at home safely.
Thank you. Magistrate?
So if I had to, I guess my advice would be that, you know, it's worth the effort, the time, the sometimes frustration, and the funding conversations to make those decisions collaboratively. I think that in our jurisdiction, it's taken a lot of meetings to get everyone at the table to work together collaboratively in a multidisciplinary approach and to prioritize the services in the way that we have here, and it's absolutely worth the effort. And I would encourage everyone to do so. It makes a huge difference for the families. I have the good fortune to see it every day with Family Treatment Drug Court, but just taking that time to engage everyone, professionals as well as families and individuals within the community, and have those difficult conversations about how to keep children home safely with families and prevent that disruption while maintaining a safe environment is absolutely worth the frustration and the effort and the time.
Great, thank you. Angela?
I'll answer this question. Kim from Trumbull County. My advice to our participants and attendees is to be very creative and flexible in safety planning with families that are struggling with substance use disorder, and not immediately consider bringing those kids into care. Obviously, I'm going to recommend that they involve family peer mentors who have both lived experience within child welfare as well as substance use, as either partnering through a behavioral health provider or hiring them within their child welfare staff to help engage families sooner and to get them into treatment, as well as making sure that your existing child welfare staff are trained very well in motivational interviewing techniques and solution-based interventions rather than just focusing on the problems.
Great. Thank you. So with that, I just really wanted to thank our panelists for joining us today, taking the time out of their days to support us and share their experiences with the field. It really is invaluable. With that, I will pass it back to William to share a couple things and close us out. Thank you.
Great. Thank you, Ashe. And thank you to our panelists as well and our presenters for a great conversation. Just a few reminders before we wrap up for today. Please note that you may contact Intech through the website displayed on this slide. You may stay up to date on the latest information by signing up for Intech